Hello, I'm Dr. Daria Sharkova, and today we have another episode of Houston, We Have a Solution with Rafael Boza, who is a special counsel at Pillsbury, Winthrop, Shaw, Pittman, LLP. That's a very long name,
Yes.
but I've learned how to pronounce it correctly. So today we'll speak about the Houston's arbitration advantage in the change in Latin America. And first of all, we of course want to know what's Latin America, because is it South America? Is it part of Central America and South America? So Rafael, tell us what's Latin America.
Well, first and foremost, thank you very much, Dr. Shirokova, for having me. It's a real pleasure to be with you here and to discuss a little bit of arbitration in Houston and in Texas, as opposed to other places in the world. To answer your question, what is Latin America? That's kind of a broad question and a little bit esoteric. Some people think it's anything south of the border, and sometimes it could be right, but Latin America is more a cultural region than a geographical region, and it's based on the Roman languages, countries that speak Roman languages, including Spanish, French, Portuguese. And it includes not only Latin America as, South America's geographical region and Central America as a real geographical region, but I also include the Caribbean countries and even Spain sometimes.
Mexico?
Of course, Mexico. Yeah.
Probably some parts of Texas as well, if it's based on language.
we could possibly say that, that McAllen, Brownsville, those areas are in the border are probably.
Are you from Latin America, Rafael, yourself? Tell us a little bit about yourself, how you ended up in Houston.
Yes, I grew up in Peru. I was born in Belgium, but how did I end up in Houston? It's a funny story because it was through my wife that I ended up here. I was coming back from doing an LLM in Europe and came to visit some family who live here in the city. And in the first weekend that I was here, I met my wife, and I was supposed to stay 2 weeks. I stayed 3 months.
Well, I hope you didn't overstay your visa.
I did not. We did the long distance thing for a while, and then we got married. And I was working for the Peruvian government at the time. And like many cases in Latin America, there was a change in government that put my position in the government, which was somewhat political. I was an advisor to the Ministry of Foreign Trade in their staff of attorneys. So it was uncertain what the future was going to be. So we decided to come back, and I went back to law school in the US, got my JD, and now practice here. I've been practicing in the US for 17 years since I graduated in 2009. So yeah, it's been very good. I really enjoy being in Houston. Houston is a very diverse city, lovely place. Sometimes it's hot, sometimes it's very cold, but we love it.
You suggested to talk about the change in Latin America, Rafael. Why did you suggest this topic? What's going on in Latin America?
Latin America tends to be one of those continents that is always in flux, changing all the time. And most of the changes that we see are surprising, and some of the changes that we see are not so much.
What are surprising changes now?
Well, we can talk a little bit about Mexico, which is a very surprising change that has been evolving and coming in the last few years, particularly with the governments of López Obrador and Claudia Sheinbaum. And now with Claudia, we're seeing a deepening of the changes that are surprising, let's say, including, the judicial reform, the energy reform, the constitutional changes that are limiting amparo. And in general, it looks like a weakening of the democratic process and the democratic institutions in Mexico. On the other hand, you have Argentina, with Milei, that is showing progress and promise from a very, very dark time economically that they had. And in Peru, we just had a change in president. So we have had like, I lose count, but we may have had like 10 presidents in the last 8 years. So there's a lot of change, a lot of things to talk about, and those changes, political and social changes that we see happening, have a very big impact in the disputes and investments and how people perceive, the courts in different countries and different states, and that makes for those investors, those parties that are there to look for venues and institutions that will be able to provide fair and prompt resolution to their disputes.
We have listeners from all over the world. So can you tell us more about the judicial reform in Mexico? Everybody hears about that, right? But not a lot of people understand what's going on, at least your perception of that.
Of course, it's a very complex process that started with a change in the constitution and included the election of judges, which is not a strange thing for us in Texas, because in Texas we also have elected judges from the lower courts to the Supreme Court. And for Texas, this has worked very well because it has certain requirements for you to be a candidate and for you to be able to run. But in Mexico, that they adopted something similar, and and it's going to be applicable at the federal level, particularly, but also at the state level in many of the states of the country. And the federal judiciary was trusted in Mexico. It was until the change, it was a trusted institution, even though it took long to decide cases, etc. But it was generally trusted. So now the change has meant that a smaller group of people, not because there is smaller courts, but because the party in power, Morena, has basically taken control of the judicial power with their candidates. And the first round of elections happened in June, and they elected part of the Supreme Court, which was reduced from 11 to 9 justices. And now the president of the Supreme Court is Morenista, as well as the other members. So there is a real concern about the neutrality and the justice system in general, because you have a justice system controlled by the same government that controls the executive, or the same party rather, that controls the executive and Congress. So
no separation of power.
There is no separation of powers anymore in Mexico, which was something that the federal judiciary really provided, even though, Peru, for example, has been in power many times over the years, and they have had as well, the executive and Congress, but they didn't have control over the judiciary. So that is being lost. So this it's a situation that is evolving every day. There's something new every day.
So these are surprising changes. What are the non-surprises changes? What kind of constant in Latin America?
Well, not surprising changes. There are not that many. We always see things that are surprising. For example, in Bolivia, just last week, we have a new president that is now right-wing and not really very right-wing, not a moderate, and that is a complete 180 in Bolivian politics. So Bolivia is going to again become an interesting place to do business, but
for how long, right?
Exactly. We're going to have to be very careful, because how long is it going to last? Is the population going to change their mind when, wallets start hurting?
It reminds me of this story with Ecuador, right? When Ecuador trying to renounce the exit convention, then they sign it again.
Yeah.
So some instability.
Always instability, always flux, always change.
So that's some kind of status quo, and we have the instability. But why do you think that these changes, surprising or not surprising, will attract interest to the neutral arbitration places? What's the
Well,
legal base for that?
the legal base for that is, as I said, you're losing a little bit of the separation of powers in Mexico specifically, and the same happens in other places when you have this flux of changes, political changes. So investors get nervous, you know, and when you don't see that you have a path forward that seems reasonable within the jurisdiction in which you're working, you try to look outside. Now, the changes are going to take time because you have to include in your contracts, you know, arbitration clauses that are going to provide for a neutral forum such as Houston. But and those contracts have to become a dispute, or disputes have to arise under those contracts. So those changes are going to take time. In the meantime, you're kind of stuck with what you have. In particular with Mexico, investors from the US and Canada, actually only from the US, have the ability to use the USMCA to a certain extent, because there is a club of industries that are protected and under the equivalent of Chapter 11 under USMCA, but not everybody is. So those that are not protected are going to be more eager to renegotiate their contracts specifically to include arbitration clauses.
So what are the industries protected by this equivalent of Chapter 11?
There are a few industries, energy for sure, oil and gas, electricity, if I'm not mistaken. I don't have the list in front of me, but those are the ones that come to mind immediately.
Actually, that brings us to a different question. Next question: what industry in Latin America are most likely, in your opinion, to generate this possible disputes with Houston as seat of arbitration in the future?
Yeah, the industries are kind of the traditional industry, and for Houston specifically, energy is going to be the big one. You know, all investments that we have in Latin America related to business would benefit by having arbitration in Houston, even if they have to renegotiate their clauses, as I mentioned. Why energy? Because, you know, Houston is the energy capital of the world. All the major energy companies in the world have headquarters here or major offices here. And in general, the bar is very experienced on energy transactions of all kinds, from, you know, downstream to upstream and everywhere in between, include trading, pipeline transactions, you name it. People are very experienced here, and I think energy is going to be a driver for Houston as a seat. Now, I think infrastructure and EPC contracting is also going to be very big. We're going to start seeing the development of alternative construction projects such as data centers, not only in the United States, but also in Latin America. And I think mining is going to start being a very big source of business for Houston, because Latin America has huge reserves of lithium and rare minerals in general that are going to be critical for the development of technology, especially in the next 3 or 4 years, where the Trump administration is putting such an emphasis on data centers and technology. Do you have a question?
We have a comment by Rodolfo Rivera. So I guess he's speaking about Mexico. The movement began after the courts ruled against several Morena initiatives. I'm in-house and did a deep dive into the reform. Also, a number of in-house lawyers are looking into arbitration in Mexico. Can you comment on that, Rafael?
Well, I know that a lot of people are working on and looking into arbitration in Mexico, but I worry about enforcement. You know, once you have the award issued in the seat of Mexico, what are you going to do with it? It's going to be a little challenging to enforce it in Mexico.
Yeah, even setting aside is more dangerous than enforcement, right? If you have
Right.
it in Mexico, then you can apply for setting aside the award. And how will the courts in Mexico
You have an
interpret that, right?
inexperienced judiciary that is going to be reviewing a very complex, possibly very complex arbitration award, and it's going to be difficult to enforce. Now, if you take it outside of Mexico, it's going to be protected by the New York Convention, so you probably will have equal faith and credit on the award as it would be issued in Houston. But I think the other topic that is important to consider is the support that the courts are going to give to your arbitration when you need it. So again, an inexperienced judiciary will take longer and probably provide less effective support to your arbitration as opposed to a very, very experienced judiciary in Texas.
Actually, thank you so much, Rodolfo, for your question. It brings us to one of the later questions, but I will ask it now. So, Rafael, can you tell us about the whole system of courts in Texas? A lot of people have heard that now we have the Texas Business Court. We also have the Fifth Circuit Federal Court, right? We have Texas courts. Can you explain a little bit this, how they interact? What are the options of people who want to have seat in Houston?
Yeah, so when you select the seat in Houston, you're selecting Texas courts and federal courts in Texas, Fifth Circuit as your support system. And we have basically it's an onion of regulation that you have to go peeling. You also always start with the rules in your case, whether it's ICC or AAA or ICDR or whatever rules you're using. You always start with that. And second level is going to be federal, because federal rules, for those of you who are not U.S. attorneys, or
we have quite a lot. So can you explain?
So the federal level, the FAA, the Federal Arbitration Act, and the rulings of federal courts in the spectrum of the Federal Arbitration Act are above the state level, preempt the state level. And then underneath, Texas has two, is a dualistic system. They have two laws. The Texas Arbitration Act has basically two chapters. The local chapter in general is chapter 171 of the Civil Practice and Remedies Code that provides for domestic arbitration and the general rules of arbitration. And 172 is specific for international disputes. So that's kind of
What are the international disputes, though? How do you define that it's an international dispute to which this part will be applicable?
Yeah, the basic definition is similar to many others. Is based on the model law. If you have a party that is not domiciled or not based in Texas, then you have an international case. So those are the layers, right? And then the case law that interprets not only those two Texas rules, but also the interplay with the federal, and that allows for a very strong and robust set of rules for arbitrations in the jurisdiction. I think that's the structure, let's say, the backbone of what Texas offers in terms of arbitration. The Texas Business Court, which is new, it has 1 year since it was no, it has 2 years since it was enacted, but 1 year in operation, is a very interesting new addition to the judicial system in Texas. And the business court right now has a limited jurisdiction only for corporate disputes under $5 million, and also for qualified transactions over 10. So the qualified transaction definition is a little bit in flux. There are a lot of decisions of the court that are interpreting what that means, and the boundaries of their limited jurisdiction. And also there have been certain cases in which arbitration has been discussed in the court, but they don't have express jurisdiction over arbitration. So we would have to fit in one of the other two categories.
So let me just ask this question. Texas Business Court, it's not the support court. It cannot apply the Federal Arbitration Act or the Texas Arbitration Act. It's completely different.
As I said, they have limited jurisdiction, and they would apply those rules to the extent that the case fit within their jurisdiction.
Okay, I see.
Now, there is some push on the Texas legislature to try to expand them to decide motions to compel and enforcement of awards. So that takes it out of the general system. But that hasn't been enacted yet.
That's good. Great. So now, as we're speaking about all this enforcement and setting aside issues, how can you compare the enforcement system and the judicial support system in Texas with the Latin American states? As we were discussing Mexico, let's compare Mexico and maybe some other jurisdictions that you know the rules.
Yes. There's a huge difference between the way you do it in the United States in general, because you do it in the federal system, not in the state system, unless your award is a state award. On the other side, so let me back up. So for the US in general, you go directly to the federal courts to enforce an arbitration award. And the federal courts basically give that award full faith and credit, and you don't need to domesticate and do an exequatur for that award. So you basically obtain an order of enforcement if there's no opposition, and you proceed with the enforcement of the award. So it's a very short process. It could get complicated, but it's generally simple and straightforward. In other countries in Latin America, including Mexico and all the way down, except for Peru, which has a little bit of a straightforward and simpler system, you need to do an exequatur.
Because it's a civil law country.
Exactly.
Right?
So you need to go in, take your award, and the court needs to recognize it and domesticate it. And that process takes a while. So there's a huge difference in the timeline of your enforcement process between federal court in the United States and any other court in Latin America. So it's going to take the exequatur process could take anywhere between 12 and 18 months in many countries, more in some others. Specifically, a case of Mexico, if you have an inexperienced judiciary, it's going to take longer, even if you get to the same result. So that is a reason why choosing the United States in general as a seat, and Texas in particular, like Houston, is very beneficial, because it allows for a quicker process of enforcement under the New York Convention.
And what about the support judges, support courts? What techniques which don't exist in civil law countries of Latin America can the courts here use to help the parties during their arbitration?
Well, I think I don't know if the techniques are going to be different. And I don't think is a better answer. I don't think the techniques are going to be different. But I think your timing is going to be a lot shorter. When you go to a court in Houston or in the federal court in Houston, you're going to get a quick result. As to, for example, if you're in an ad hoc arbitration and you need to appoint an arbitrator, and you go to the courts to get an appointment, you will get it very quickly. Very quickly, I'm talking about 3 months, 4 months. If you are going and trying to get an appointment in a Mexican court, it's going to take you 12 months at least. It's a long process. Maybe less if you try to do it as an emergency. But again, if you go back to the inexperienced judiciary, new judges that have not been judges before, etc., it could be a problem. So that is what I think is a main difference. You will get a quicker result, a more effective result that you can enforce immediately and get your appointments when you need it. And if you need emergency measures, it's going to be the same thing. You're going to get them quicker here. Although I know Latin American courts with medidas cautelares are fast, typically, but not as fast as U.S. courts.
Speaking about the support of judiciary, do you think that any Latin American countries may at some point follow the Russian example? And by that, I mean that, some kind of laws helping the national parties to escape the arbitration, like anti-suit injunctions, which now exist in Russia, which allows the Russian parties just say, okay, I don't like this arbitration, that's why I'm just going to local courts. Do you think that that's a real danger or not yet?
Not yet. Actually, anti-suit
Maybe
injunctions.
Venezuela.
Anti-suit injunctions, no, I mean, it's probable, but it hasn't happened yet. Anti-suit injunctions are more let's start with a main premise and dispelling the myth that they happen a lot. They don't happen a lot. They are very, very uncommon and very narrow when they happen. So do I think that countries like I don't know, Peru, Argentina are going to start saying, well, I'm gonna allow anti-suit injunctions and get arbitrations in the United States?
Anti-arbitration injunctions as well.
Anti-suit injunctions against arbitrations in the United States. It's entirely possible, but it hasn't happened yet.
And we all hope that Latin America is going on the road of democracy and not the
that's
diverse
true.
one.
But also you need to think, what is the enforceability of that order outside the country in which it's issued? So if I bring a Argentinian court order saying to the federal court to stop doing what they're doing, or to a US arbitrator to stop doing what they're doing, it's very unlikely that it will be enforceable or enforced. We will run into a situation like the Comisa case, in which the Second Circuit analyzed the committee.
Okay, can you tell us more about this Comisa case?
Sure. I mean, in the Comisa case, which is a long-term case, there was a company, EPC contractor, that built some infrastructure for Pemex, offshore platforms, if I'm not mistaken. And then they got into an arbitration. There was an award for $400 million. There was a change in law in Mexico. The judiciary vacated the award. Comisa brought the award to the US for enforcement, and the Second Circuit enforced it after, the district court had decided the same way as with the Mexican courts, based on deference, committee principles. And the Second Circuit basically said, I'm sorry, but even taking into account the deference principles to the other court, I really cannot accept the reasoning. So I'm going to enforce the award anyway. And that never got to the Supreme Court because the parties agreed on a settlement. But that I think they will be faced with something similar to that. While I respect Argentinian courts and their orders, I'm not going to enforce this one.
Thinking about difference of courts in Mexico, for example, and here in the US, do you think that the Texas courts are more practical, which goes maybe to this difference between the two cultures, two systems, civil law versus common law?
Well, you had one of your interviews on specifically that point.
Yes, and I would like to know your opinion on that.
My opinion on that is that practicality, it plays a big role in what the courts decide. But I think the courts rely heavily, of course, on the law, and they're very committed to the law more than to the practicalities of the case. Although if you make a practicality argument and you say, Judge, this doesn't go against the law, but is a practical solution to the problem, then that could be something that they do. And you may find yourself in a forum that is more receptive to that kind of argument here than in a civil law country.
Speaking about the advantages of Houston as seat of arbitration, that will be the last question on this subtopic. Do you think that the awards rendered by arbitrators seated in Houston will have more weight, or somehow will be more will have more advantages in comparison to arbitral awards rendered somewhere else? If people, because where would you enforce these awards, right? Normally you enforce where the companies have the assets, or if it's a state, maybe you will go to Washington DC and try to find some property there, right? So in these two cases, well, first, do you think that the companies have assets in the US? One.
Many companies do, and yeah, most of the big companies do, and I think even the state companies would have some sort of assets in the US, be it a bank account or something similar.
What about the states, for instance? If you want to enforce against the state, do you think that the award rendered in Texas will have kind of more advantages in US courts than the award rendered in other countries?
Well, you have the New York Convention, obviously, that protects all awards equally. So from that perspective, I don't think an award issued in Texas will have any inherent advantage to an award issued in Mexico City or in Lima, Peru. It doesn't really, under the New York Convention, you will be able to enforce it in the same way. Now, there are practical considerations that you need to bring to bear when you are assessing where are you going to spend your money in the enforcement. And part of that is knowing or analyzing where are the assets of the company, where can you establish personal jurisdiction to enforce the award. So although you are protected by the New York Convention, there are other practical considerations that need to come into play when you are enforcing an award.
Thank you. Now let's talk about our competitors. What places are Houston's main competitors, in your opinion?
Well,
who should we go after?
My opinion doesn't count so much. I was reviewing in preparation for this.
Wonderful.
I was reviewing the Queen Mary report.
Okay, tell us about
the 2025 one, actually.
And I love Queen Mary, right?
Yeah,
we always happy.
And they provide us with a little information that says that London, Paris, New York, Singapore, and Miami are the preferred seats for parties in the Caribbean and Latin America. As you know, this is kind of a survey, and they send the request answers from practitioners in the different countries. So respondents from the Caribbean and Latin America choose London 48%. Kind of, I mean, and we know London.
That surprises me, actually.
That surprises me as well because of the distance and the complexity of the logistics. But to the extent, I think, to the extent that your contract is selecting the laws of England and Wales, which is not entirely uncommon down there, especially when you're dealing with, for example, Chinese parties, etc. It is possible that London is there because of that reason.
And Singapore as well, right?
Singapore has established itself really well as a seat. But Paris, New York, and Miami are also parties. I know of several contracts for large infrastructure projects in Latin America choose Paris as seat of arbitration. So apparently, London continues to be the biggest place. Paris is second, New York third, Miami is listed as fifth. Houston is not listed because I think we are kind of just now developing.
That's right. That's right.
And your efforts, of course,
Thank you, Rafael.
are making it more known. But I think Miami has really historical ties to Latin America, not obviously starting with Cuba, but a lot of people from Latin America has connections directly or indirectly to Miami and to South Florida.
I would say we will be friends with Miami, but we will compete with everybody else.
I think we need to be friends with Miami, but also compete with Miami.
Or we can
One thing doesn't exclude the other.
Oh. Okay, meanwhile, we have a comment from Gabrielle. Hello, excellent webinar. I have a question. In practice, has it happened that an arbitral award is contrary to what was decided in a criminal trial? Let me find it. No, you'll find it. Has it happened that an arbitral award is contrary to what was decided in a criminal trial that was subject of arbitration? What has been done in that respect? What has been done in that case?
I don't see how arbitration would be directly impacting a criminal trial. I mean, if there is the only instance in which I can think there would be an overlap is if you are if the criminal trial is relying on assets or dealing with perhaps some assets that could have been I could think cases of corruption, for example, in which government assets have been used to pay bribes or money has been money that should have been paid to the government has been used to pay bribes. In those cases, I don't see how I mean, the arbitration would potentially interfere with the criminal case, but in general, I don't see how the overlap would occur. I haven't had that experience, at least personally.
Let's go back to our discussion about Miami and the other competitors. So what are the advantages, cultural and linguistic advantages of Houston? Also, maybe geographical advantage. Let's speak about that.
I think Houston has a very deep integration with Mexico in particular. You know, 40% of the population of Texas identifies in one way or another as Hispanic, and of that amount, about 38% are fluent or bilingual, identify themselves as bilingual. So you have a very strong dynamic with Mexico, not only because of historical reasons, but also because of proximity. Then you have a very strong bar. You know, about 6,000 attorneys in Texas identify or represent that they can conduct cases in Spanish and serve clients in Spanish, which provides for a huge bar of attorneys that are really ready to serve Latin American clients.
And explain as well, right? It's easier to explain in Spanish some intricacies of US law and
absolutely
what happens.
Absolutely.
Courts,
and
right?
communicate with your client in its own language, right? There is deep ties also in terms of commerce, you know, with Mexico. It is really unknown and unbelievable how much trade occurs between between Texas and Mexico, and how much deep roots are going from Mexico to Texas and from Texas to Mexico in terms of, for example, in terms of gas trading. I mean, there are so many pipelines that go down to Mexico that is unbelievable. Now, other countries are a little less connected, let's say. As I mentioned, Florida has established itself since the 50s or even earlier as a direct hub to Latin America, and a lot of people love going to Miami.
Mhm.
It's so pretty.
Yes, it is
Um,
pretty. Maybe prettier than Houston.
Maybe, maybe.
Maybe.
But the same thing is happening here.
Mhm.
Houston has a real direct connection to every single capital of every single country in Latin America.
Mhm.
You can hop on a flight and arrive without having to take any connections, which is great. There's a problem of affordability and competition, I think.
Mhm.
We need more flights out of Houston to Latin America without connection. We need more direct flights. And I'm not familiar enough with the regulations or how the system, the market of airlines work, but whoever is listening and is
But I've noticed you're in the same building as United.
exactly. I knock on their door every day requesting that they
You
put
should
our flights.
request.
But that's
Rafael
only,
can do it for us.
that's only one airline. We need more airlines.
Well, you shouldn't tell them that.
You need more airlines. And now we have I just read yesterday that there are some issues arising between the US and Mexico related to the construction of the new airport in Mexico City.
Mhm.
And the fact that the Mexican government of López Obrador
Mhm.
was trying to force some airlines to fly out of the new airport instead of Benito Juárez.
Mhm.
And that was creating some issues and some tension with the Department of Transportation here in the US. That's a developing story. I don't have all the facts, so
Mhm.
that's one of the issues. We need more routes. We
Mhm.
have like 4 or 5 flights to Mexico City, but we don't have 4 or 5 flights to Lima. We don't have 4 or 5 flights to
Mhm.
Bogota, Sao Paulo, Rio, Argentina, Buenos Aires, Santiago, you name it. There are flights, and there is at least one a day, but we need more.
Mhm.
We need
What else can we do to kind of reaffirm our position as a city?
What else can we do? I mean, I think people need to come and know Houston. We are getting Houston is to a large extent the sister city of Lima. You have fantastic food, better than any other city in the US, in my opinion. So food tourism could be one way to attract people. But the main issue is people need to come to know Houston as well as they know Miami, and that is going to take a little bit of time, and I think events like this and presentations like this are going to definitely help raise awareness.
Now let's just go to the most pleasant part of our webinar. Tell us about places where you can bring clients. Are there any Peruvian restaurants in Houston?
So yeah.
Because
Yes.
Miguel told us there are no Argentinian restaurants in Houston.
Oh, I don't know about
Not
Argentinian
ones, he
restaurants.
said. But tell us about Peruvian restaurants and your favorite restaurants where you would bring your clients and friends.
Peruvian restaurants, there are a few.
Mhm.
There are a couple of really good ones, and my favorite is one called Latin Bites. It's not it represents itself as a Latin American cuisine, but they are 90% Peruvian.
Mhm.
And it's a really good restaurant. But I mean, there are so many places to go that are really fantastic food all over the place.
Just list 3 places here in downtown Houston where you can bring your clients.
Okay, number 1, you can take them to Morton's, where you can get a fantastic.
It's not Houston
Well,
specific.
it's in downtown, so I like it. It's a good place to go. They have a great steak.
Something more unique.
Brennan's is a great place to go. I particularly like the one in the Bayou, because it's a great steakhouse, but also has a great view. Another places in downtown, I mean, you have many places to go for business, but they're not really that remarkable. There are places outside downtown that are really.
What about places outside downtown?
Remarkable, like in the Post Oak area, you have like maybe 4 or 5 restaurants that are really good. I cannot name There's one called Joey's, I believe, that I really like. I have been there maybe twice. It's new. Montrose.
Montrose.
There is a place called the Montrose Collective that has 2 or 3 really good restaurants. I love sushi, so Uchi is great. Uchi is all over the place, but
What about best Peruvian restaurant in Houston?
Latin Bites.
Sorry?
Latin Bites.
Latin Bites. That's something we should try.
Yes, definitely.
Okay, I see that we have some comments. Oh la la, that's a very long comment. Okay, can we take one last question?
Yeah.
Okay. Interesting and thought-provoking debate. Thank you so much. Question, Chapter 3 of the Federal Arbitration Act implements the Inter-American Convention on International Commercial Arbitration,
Yes.
also called Panama Convention.
Correct.
Section 305 deals with the relationship between New York Convention and Panama Convention, and it says that unless the parties expressly agree, if the majority of parties to the arbitration agreement come from both conventions, Panama Convention applies. In the Americas, the U.S. Yes, I'm trying to find the whole text. Okay, yes. Yes, Panama Convention applies. In the Americas, the U.S. and all Latin American countries have
acceded
to
Panama
That's a
Convention.
very, I have acceded to Panama Convention. As far as petitions for the recognition and enforcement of arbitral awards are concerned, have you seen reference to the Panama Convention before Texas courts? Or this is rather a moot issue because parties just refer to New York Convention. I see an importance of Panama Convention to enforce an arbitration agreement when it is an empty one, i.e. without indicating means to start the arbitration.
I in fact have a Panama Convention case on the it's not fully fledged yet, but it's going it's in the pipeline.
Can you tell us without disclosing the details, but still
Well,
in general, not about the case, but
the Panama Convention provides, you know, very, very similar protections to the New York Convention, and I think it was. I don't have the travaux préparatoire or anything like that, but I think it was initially designed as a tool for South American countries and Latin American countries in general to enforce awards between them when not all of them yet had signed the New York Convention. Because back in the 50s, when the New York Convention was adopted, 1958 specifically, we have to remember the context, the historical context of that. You know, Latin America was not what it is today, and it was a lot more reluctant to engage with the United States. So I think part of that is the New York Convention was an effort by the United States and the United Nations in conjunction to try to push for this global framework, while the Latin America and the Panama Convention, the Latin American countries wanted their own thing in the Panama Convention. And I think the overlap is really remarkable. It's very similar. So I think the Panama Convention is a useful tool. If you're going to enforce, you can do it under both. You can say, look, the New York Convention favors me, and also the Panama Convention favors me. So I don't see why would you have to be exclusive in this situation.
Thank you, Rafael. I see that our time is coming to the end. So thank you very much for coming and answering all the questions, and also being so specific on some Texas and federal courts distinctions. I think that really helps everybody. So thank you very much.
It's a real pleasure to be with you. Thank you so much for having me, and let's get Houston to be the seat of arbitration.
Even greater. Let's make Houston great again. Thank you so much.